Honor, good afternoon. Calling Commonwealth versus Kelsey Fitzsimmons. This is docket number 2025-311 before the court and the defendant's motion. If the parties would please identify themselves for the record.
Good afternoon, James Gubachowski on behalf of the Commonwealth.
Good afternoon. Good afternoon, Attorney Moriarty for the Commonwealth. Good afternoon. Good afternoon, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons. Good afternoon.
Hello, Your Honor. Timothy Brado for Kelsey Fitzsimmons. She's present in the courtroom today for the record to my left.
Good afternoon, Mr. Fitzsimmons. Good afternoon, everybody in the courtroom.
Thank you.
So I received the defendant's emergency motion for immediate release from the SCRAM order. So I'll hear from the moving party.
Thank you so much, Your Honor. Judge, this is an issue that causes Ms. Fitzsimmons a lot of pain. And I don't want to conflate her being able to pass the test because she's been passing them, but she has about 4 hours of pain and dizziness afterwards. And you know, I don't think anyone, and I know the court would share my thought that this shouldn't be a torture device for her. This shouldn't be something that causes her pain, impairs her rib healing, et cetera, et cetera. So, you know, we're not trying to get any sort of advantage over anything. We just want her to not, A, to not be in pain for hours after these tests, and B, you know, we just want her to not have the anxiety that if she has a difficulty doing it, that she's going to get a knock on the door and get locked up. We were told by the Elmo people that, you know, they may have to issue a warrant, and thankfully they didn't. And we appreciate, you have Mr. January's email regarding his own observations about what happened. And, you know, I think that says it all. That's someone that has no bias or interest, and you know, probation enforces court orders, and that's that. And he is telling the court this is a problem, and you know, this is something that should be addressed. And
okay.
So I see this as a simple adjustment of terms.
I don't see it that way. Just so you understand where I'm coming from, I don't see it that way.
Okay, can I?
Okay.
I don't understand what you're saying, Judge.
Okay, what I'm telling you, it's not a simple adjustment. One of the reasons she was released, and one of the reasons to ensure the safety of the community was for her to be alcohol free. If she cannot do that or will not do that, that changes everything.
She's happy to be alcohol free. She doesn't wish to be alcohol free. It's just the means of determining that's the adjustment. That's what I mean when I say this is an adjustment that.
Well, a SCRAM is what was ordered. Now, was she unable, when you said that there was a knock on the door, explain that to me. What happened?
No, Judge, that we don't want to have a knock on the door. She's living in fear of there being a knock on the door because of these tests. And it's just not between the physical and then the mental anxiety. This is a very significant issue for her.
Okay.
And that, you know, we just want to adjust whatever means the court wishes to test her or figure this out is fine with us. But this is just a very difficult environment. And just that's something that I just want to ask the court to adjust somehow.
Okay. So you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email. It's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't want to put anybody on the spot, but we have the person who sent that email here.
Okay. So you have a burden, it's your motion. What do you want to do?
Well, Judge, I don't think that is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
Well, then you have an affidavit from Ms. Fitzsimmons and you have an affidavit from her mother of the physical observations of what happens. I think that's, you know, the more persuasive evidence than a doctor saying something to the effect of, you know, I think it's self-evident and it's common knowledge that if you have broken ribs that it's hard to breathe.
What evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother. You have an affidavit from Ms. Fitzsimmons, and the other day we were here, I submitted I believe I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I just would just argue that it's somewhat self-evident as well. Thank you. That it's somewhat self-evident as well, and that, she's having great difficulty here. It's been observed by probation. It's been attested to by her mother, and it's been attested to by Ms. Fitzsimmons. So it's just a very difficult scenario for her that luckily she has passed the test, but then she's got hours of pain afterwards. And the one that she had difficulty with, out of an abundance of caution, we were dealing with Elmo, and we were informed that they may issue a warrant. And
So I want to
then-
hear about the one she had difficulty with. When was that?
Wait a second, 1 moment. Well, so that's what I was saying, Judge. I don't want to conflate passing with not having difficulty. She has difficulty with every single test. And so she passes them in great pain. So she's had difficulty in every single one, equated, it's in the affidavit. So she has difficulty on every single one. So that's a different issue than passing the test. So she's experiencing difficulty all the way through. But the one that she was unable to was 9/9/25 at 3:09 p.m., I guess.
And was that a required test that she was to do?
Yes,
And she was unable to perform it?
correct.
Okay. Was she unable to perform it?
No.
What happened?
No. So since she's been released,
Yes, swearing off. The
Raise your right hand,
probation
please.
officer.
Do you solemnly swear you will make true answers to such questions that may be put to you by the court or upon its direction, so help you
I
God?
do. Laura, if I could just pass this up, this is
Sure.
information pertaining to all of our students.
And is that being submitted, Attorney Braille, as an exhibit for the purposes of this hearing?
Judge, I'd be more than happy to do that.
It's not more than happy to. You're either doing it or not.
Yeah, sure. Go right ahead, Your Honor.
Okay,
It
so we'll-
just says that she passed the test, which is not an issue. The issue is that she's in extreme pain while doing it. Whether she passes it. or
Okay,
not.
so there's one, Officer January, that says incomplete at 9/10/25 at 3:09 p.m. Is that right?
That's correct.
So what does that mean?
Yeah. So what it means is there's a scheduled test that's programmed daily for her to be alerted and to initiate a test. And that happens. And so initially she answers the alert and attempts to take the test but is unable to complete the test. And based on my information, my conversations with Elmo is that is when she has difficulty either blowing as hard or as long, or a combination of both, into the machine to complete the test. So what happens after that is there are additional attempts to complete the test, which she tries, and then ultimately on that particular date, she successfully completes and passes the test on September 10th at 3:50 p.m.
Okay, what I have in front of me is an incomplete test at 9/10/25 at 3:09 p.m.
That's correct. And then if you just look
And then
right
it
above
says
that,
passed at 9/10/25 at 9:30 a.m.
okay, so you're looking, I'm referring to the second document, it's multiple pages.
Mhm.
I think if you just go up instead of the one above it, the
Okay.
incomplete is the. nine-
So it's 3:09, it's incomplete, and then at 3:50 she passed.
That's correct.
So that's a period of 40 minutes?
That's correct. And you'll see the same thing.
So the other one, which is
September 9th, yes.
September 9th,
Again, at 3 o'clock.
she passed, but she,
The test is initially incomplete.
at 3:09 and then it's complete at 4:21.
Yeah, 420, 421.
So there were 2 times that she had an incomplete test. Is that
Yes,
correct?
Incomplete, and
And what's the procedure of the probation department when somebody who has a condition of release to have SCRAM and to pass the SCRAM test in a very serious case if they're incomplete? And I have 2 incomplete tests and I was not made aware of either one of them.
so my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of
And so
an hour and 20 minutes.
that's correct. Now, in conjunction to the hour and 20 minutes, we also know that, and I observed it firsthand, that whatever the injuries are, which I don't know, actually doesn't really matter to me. But when I was doing the installation process and observed what was genuine pain, like genuine
Okay.
pain. So I know,
Any objection to any of the terms used by the probation officer? Okay.
so we have all that information. We don't deem that non-compliant. She's attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance, and with her obstacles.
What do you, I'm getting confused. What do you mean compliant?
That's-
As far as when
that's-
she was initially,
That's compliant with SCRAM testing. She was ordered.
when she initially was, started to be monitored by SCRAM and you went through the preparations, is
Yeah,
that right?
that's correct.
Okay. So when something is incomplete, do you typically bring it to the attention of the
No.
court?
No, that's not what we do. So if something is incomplete, as in this case, at 3, on September 9th, at 3:09, we have an incomplete test, which is a scheduled test.
Mhm.
And then we have, that's simply not the non-compliance. If she had missed the test, that would generate additional responses from Elmo, and then that would determine whether or not there's actual non-compliance. If someone missed a test because they were down in the basement doing laundry and then came up and realized that they had a test, took an on-demand test 20 minutes later and passed the test, which means there's no alcohol in the system, we don't deem that as non-compliant. That's compliance. If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, if she failed to respond or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notice and notify the district attorney's office. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's,
Well, that's
to
your
me,
position that's non-compliant.
Well-
It's really up to the court to decide whether somebody's compliant or not with conditions of release. What you're saying is those situation that you
ever-
described is what you deem as appropriate to bring before the court.
It would, so I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation or from our end.
Right.
Because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober, and that's not, we don't deem that non-compliance. And we never have, and we never would, in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. And so, the schedule for her to be tested is something that we discussed. It wasn't ordered by the court. The court ordered someone to be alcohol free.
What do you mean we discussed? So she knows when she's going to be tested?
With Ms. Fitzsimmons. I discussed with the defense counsel about creating a testing schedule, because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency of testing that was ordered by the court.
It was
4 times a day, 3 times a day. None of that was ordered. She was ordered.
It was random screens, excuse me, Ms. Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule,
With
as we always do.
Okay.
As we always do. Not in this particular case. We always do.
It was random screens that were ordered.
Judge, I don't have that. I don't have random screens anywhere in my materials, for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I could clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with SCRAM testing, we always default to creating this testing schedule,
Okay.
and up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. And the test to be done randomly. And at that point in time, we would take her off a schedule, and then we would notify Elmo to be tested 4 times a day at random.
Okay.
So that's done on this case, and it's done on every case.
Okay. Attorney Bradle, do you have anything else to submit?
Judge, I would just offer, I respect and I heard your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also.
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard with the email.
All right, so the email is excluded. Anything else, Attorney
No, my
Bradle?
objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, it says comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something. My email, and I know but it's important that the court knows, I didn't make a recommendation that SCRAM condition be vacated. I never did that. I never suggested, is all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court sua sponte?
If the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I
Because
haven't
this-
said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's
Thank
for the motion to vacate the SCRAM device. So do you have anything else to submit, Attorney Brado?
No, Your Honor.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is in light of the court releasing the defendant, that testing be done.
Okay. Attorney Brado, I'll hear, first of all, I do have a question. So Ms. Fitzsimmons is able to do the SCRAM, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
I think, that depends on whether the court is willing to tolerate that the material represented in the
The court
affidavit.
is not tolerating anything, okay? Let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to SCRAM. If she cannot do that, I need to know that. Can she do that or not?
She can do it
Okay.
under the terms that are
So-
laid out in the affidavit.
So you're saying she can do it on her own terms?
With significant pain and dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all. So I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for lack of alcohol, that's completely fine with the defense. But just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Oh, okay.
But
It is not this court's intention
I understand.
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the SCRAM as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that
Okay.
can be put in there as well. But Judge, I think that, that there's probably other alternatives that she could do that I believe are out there but I know that might step on the court's other order for house arrest, that she would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol. That's
Okay.
not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes. I'll break.
Court, all rise. Goes back in session, is it?
Your Honor, we're back on the record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws, Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to SCRAM monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the SCRAM installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by SCRAM, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by SCRAM. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a written order will
May I
follow.
address the court?
That's the court's order. Thank you.
All
All
right.
right, Jack, I ask you to stay your order pending the SJC. And there are other alternatives Your Honor can accomplish.